not necessarily in the moment, but later on when somebody might need to actually receive care in assisted living or a skilled nursing facility, and may need access to Medicaid. So these are a lot of things that don't seem like you're doing anything wrong, and in a lot of ways from both an ethical standpoint and on some legal side of things for like I guess just general sort of employment side of things. These are not illegal things to do, but for Medicaid, they would cause a lot of problems due to them being considered gifts potentially. So we're going to go through, we have at least 6 we're going to go through, but we do have 10 that we can go through with you. A lot of these relate to one another. So again, welcome everybody to our weekly webinar. Today, we're going to be talking about 6 common caregiver mistakes when children are providing care for a loved one at home, or children are providing care for their parents at home. We do have 10 total though, so we'll at least go through 6, I promise you that much. But I'm attorney Justin Randall with Hooper Law Office, and with me is attorney Abigail Planky with our office. And we have a couple quick things to go through before we dive into the topic today. First of all, just keep an eye out at the end of this for an email from us where you'll give 2 things. You'll see a feedback form, which gives you a place to fill out any feedback you have, any topics you'd like us to address, related to estate planning or elder law, and then also gives you a place to let us know that you'd like us to reach out to you to set up an initial consultation with our office. We schedule those for 2 hours. They are complimentary, so it doesn't cost you anything to come in and talk to us. We can, by the end of that 2-hour initial consultation, give you a pretty good recommendation of what you should do, what the cost would be associated with that planning, all of those sorts of things. And then with that email, you'll also receive our handout, which will be our top 10 caregiver mistakes that we'll kind of be walking through with you today, which can be just a really helpful reference tool going back to if you do need to start planning around the care for a loved one and you're thinking, well, what was that thing that could be a really big problem that it doesn't seem like it would be? This could be a really helpful tool for that. And then one last thing before I dive into the details, or we dive into the details today, just a reminder that next week we will, instead of doing our weekly webinar, we'll be doing our in-person public seminar at down in Oshkosh. That'll be at the Culver Family Welcome Center. If you want to sign up for that, you can do so at estateplanninglive.com. And there are 2 sessions at 2 p.m. and 6 p.m. So you'll have a couple different options to come attend, but feel free to sign up ahead of time. And if you want to come and hear us talk in more general detail about wills, trusts, powers of attorney, and then Medicaid planning as well. All right, so diving into the details finally, after my long-winded opening. We often have family members come in, especially when one of our clients is maybe getting older, needs some care at home, but they, or maybe needs care in general, but the family is trying to prevent them from going directly into assisted living or skilled nursing. They want to keep them home longer, so they offer to provide care to that loved one in that person's home. They don't necessarily have to be nurses or medical professionals, but they want to provide care to help keep mom or dad or their other loved ones outside of the facilities as long as they can, to help save costs, just quality of life, freedom of choice, those sorts of things in terms of their care. The problem is when the loved one who is receiving that care wants to pay the other family member to provide that care, there can be a lot of pitfalls that people kind of fall into accidentally, things that don't seem like they should be an issue. So when we're doing planning around Medicaid, we're often looking at, well, has this person given anything away for less than fair market value? They gifted the home over to the kids, transferred assets over to the kids, or put assets into an irrevocable trust, basically done things that would protect those assets from care. The payments to a loved one, though, to provide care in the home, that is a payment for a service that you're receiving. So in theory, that's a fair market value exchange. You're paying for something, or the loved one is receiving payment for a service they're providing. And normally that would not be considered a divestment, like if you were just to actually have a home care organization come in and have a contract signed where you're paying that person, because there's records of those payments. It's clearly for a valid purpose. You're not just trying to hide money. The problem with doing that with a family member is that Medicaid will assume that those payments were a divestment, that you were trying to hide money, unless there are certain agreements in writing and in place at the time of those payments. They will be considered a divestment. And as we know with Medicaid, it's often you are guilty until you prove yourself innocent. So the point of these agreements is to make sure that you have something in writing that you can prove to them and say, look, here are the terms of these payments, here were the services provided, and the number of hours per week, all of the things that they're going to want to see. So what this is called is a caregiver agreement. And they go through the sorts of things like what's the hourly rate that person would be getting paid? What types of services are they providing? How often are they providing those services? And then it has to be a notarized agreement specifically under Medicaid's rules. So it's not something that like you could just draw up yourself, just have both people sign it and say, we're good. It has to be a notarized caregiver agreement specifically. So this is something that we often put in place for our clients when they are trying to do this, or if somebody is coming in and saying, hey, we want something like this, but we don't want to cause a problem. So
it's also important too that what Justin's talking about is, setting that up in writing for payments going forward. And that's a big part too, is, if you've been paying a loved one, either cash or, just regular checks for providing that care, it's really important that you get something in writing, because it's difficult to go back and say, no, all of those payments were, previous care that I provided. So you want to get that in writing, so that way going forward, those payments are, considered gifts or divestments.
Yeah.
And then actually logging the care that you're doing, keeping good track of it going forward is important.
Yeah, so it cannot apply retroactively. It can only apply going forward. So sometimes, unfortunately, when people come in, this is where these payments seem like they shouldn't be a problem. You're paying for a service, but because it's already happened, that payment, we can't fix what happened before, but we can at least stop that problem from continuing going forward. So it's never too late to get something like this in place, as long as you have the authority to do this. One thing I'll say that's really important to be aware of is you either want to have this in place while your loved one still has capacity to sign it themselves, or make sure that their power of attorney documents, their financial power of attorney, allows their agent to actually create one of these agreements. If it's not in there, that could be a potential problem of, is that financial power of attorney agent actually authorized to create this type of agreement for that person? And
that's something an elder law attorney can certainly help you with. If you know that you've been paying for care, kind of paying yourself for care. If you want to have an attorney actually review the power of attorney document, either because you have capacity issues now, or you're wanting to ensure that something like this could be a planning option for your family later, and elder law attorneys, we could certainly help you do that at our initial consultations to make sure that you have what you need in place to be able to write out a caregiver agreement at that time, or if you need it now.
Yeah, and so the not having agreement in writing, that's mistake number one, and it's probably the biggest mistake that somebody could make in terms of providing care for a loved one at their home, is make sure these agreements are in place. I mean, it's not a bad idea to even have something like this in place, even if you're not expecting to receive payment on a regular basis with it. If it's just, hey, I want to do this for free, but if you ever anticipate needing payment in the future for it, if you're taking a lot of time off of work, you need replacement of income, those sorts of things, having an agreement in place while you can is not a bad idea. Now, as the recipient of those payments, this is an issue that people often run into. That does make those payments, because it's essentially an employment contract, those are wages that person is receiving. So you do have to report them on your income taxes. You do have to eventually pay tax on that income, unless you have offsetting deductions, of course. But you don't want to not report this income, because you might be doing everything correctly for Medicaid then, but then on your own end as the caregiver, be accidentally committing tax fraud, or you might have an audit coming. So make sure that you are reporting these wages as income. And then have your tax professional help you figure out what the best tax deductions for you might be. But don't not tell them about it. Don't withhold this information, because that could be a liability for you then as the caregiver.
And you really want to treat it like an employee-employer relationship, even though that person would be a family member or a friend. You know, they're your employer, you're the employee. You're going to want to also avoid doing lump sum payments to a caregiver. You want to make sure that, you know, that caregiver is logging their hours, what services they're providing, and then kind of agree to a set payment schedule reflective of the work that they've actually done. So you run into more of a problem with something looking like a gift, or not being able to define the fact that that was for care provided, when you just do lump sum payments to a caregiver. So that's really kind of the third mistake you're going to want to avoid, is, you know, really treat it like an employee-employer relationship. Avoid lump sum payments for that caregiver.
Yeah, the issue with the lump sum, of course, is it looks like a gift, a divestment, and then you may not have actually worked enough hours to receive those payments. So by lump sum payments, we're not talking about like, oh, they worked this number of hours and they got paid at the end of the week. We're talking about someone saying, here's 20 grand, and that should cover it. Yeah, that should cover it going forward. Sure. And those are the issues with that. Another really common thing I think that people do is they'll say, well, I'll give that person, the caregiver, I'll give them a larger percentage of my estate when I pass away to make up for the work they've done. And so that's not a problem for Medicaid, because you can say whatever you want in your estate plan of who gets what and what percentage they receive. The problem is that they may not actually receive that extra value, because if you actually do end up needing long-term care and going into skilled nursing, or assisted living, and you do spend through all of your assets, well, they might be getting a larger percentage, but that's a larger percentage of a lot less than maybe you were intending. So if you want them to receive compensation for this care that they're providing to you, make sure that they actually receive it while they're doing it, because that's the way you guarantee it. Yes, it's taxable versus a taxable income, as opposed to potentially just a cash inheritance where they wouldn't have to necessarily pay tax on the receipt of that. But you're at least guaranteeing that they will get some compensation for it. It's great to say, you get 10% more than everyone else because you really helped me out. But if if it's 10% of nothing, that doesn't help them, right? They're not getting extra value. That's not to say that you would necessarily pass away with nothing left, but they may not receive fair compensation either. They might still get more than everyone else, but if it's not fair compensation, that's probably not what the person receiving care would have intended either. So
another point is talking about, if we're looking at separate from maybe a specific amount of money or a specific percentage, sometimes people have, caregiver children who potentially live at home with them, or they're in a way wanting to say, okay, my biggest item of value that I'd have would be the home. So the priority is, giving the home as compensation to the caregiver for what they've done. And we're kind of more focusing on that point, both in related to potentially gifting now, gifting the home to a caregiver now, which you're going to lose out on some tax planning options for you. So outright gifting is kind of another conversation that we often have with families related to Medicaid, but also the idea of, when you pass, if you set up your estate plan to gift the home to the child as compensation for what they did for you. Often, when you've accessed Medicaid, yes, you can have a home and access Medicaid, but there can be a lien placed against your home for up to the value of what Medicaid had actually paid. So that's a state recovery. So if your intent was to leave the home to a child, to the caregiver child, and then a lien was placed against the home and ended up eating up all of the value of the equity that you have, which is really common for individuals who access Medicaid, depending on how much Medicaid has paid. That's where actually a state recovery would come and take the home, and that ultimately wouldn't pass to that child that you had listed.
Yeah, and another, there are exceptions to gifting the home to a caregiving child where that doesn't create a divestment, but it's such a narrow exception that you don't want to rely on that as a planning tool. So it requires that parent receive certain types of long-term care too, not just any type of long-term care for the exception of that gift to occur, and for it to not create the divestment for care. So you want to just be very careful and think that, well, hey, there are some ways that the home could be gifted to a caregiving child and not have that create a divestment, but don't do it before you've talked to an elder law attorney who can tell you for sure whether or not your situation qualifies for that. It is very narrow, so we don't tend to rely on it too much as this is definitely something that you can hope is going to be a good plan for you, because it requires you to receive a very specific type of care, and that is skilled nursing, not assisted living. So not everybody goes immediately into a skilled nursing facility. They might receive assisted living the entire time or for a long period of time. So you cannot meet this exception as a caregiving child to have the home be gifted to you unless that loved one goes directly into a skilled nursing facility from, at that time. So you want to be very careful with that. It's not a good reliance, or I would not rely on it as a good planning mechanism unless it meets your very specific situation. We do have a question that says, or is asking, can a caregiver agreement entail reimbursement for providing financial care for an aging parent, like paying bills, balancing bank statements, or should compensation be better detailed in like a functional power of attorney or a financial power of attorney document? So now a caregiver agreement can cover a lot of different services. It can cover like, being able to like clean the home, cook food for the loved one, provide actual like maybe medical assistance. It just depends. Transportation. Yeah. In terms of reimbursement for bills that are paid, like especially if you're paying bills on behalf of the loved one and you're looking for reimbursement, the better thing to do there is to actually, the end of that question raised a good point, bring up have a good functional power of attorney document, have a financial power of attorney document, and pay the bills as the individual directly from their assets. Don't try to get reimbursed, because then you have to have a good paper trail showing that, look, this is why this person reimbursed me this exact amount from their bank account, showing why that happened. It's much better if that's what you're trying to do, to actually have a power of attorney document, act under that financial power of attorney, and then just pay those bills as the person on their behalf, as that power of attorney.
Or if you're going to the grocery store and use their debit card,
yes,
some of the other things that are just going to make life a little bit easier for you. But if you're talking about like, well, I almost acted like a CPA or an accountant because I went and filed the tax return for this year, or I spent so much hours taking care of balancing checkbooks and kind of managing items. That is something a financial power of attorney could be compensated for also, but it's also something that can be included in a caregiver agreement depending on how you're handling situations. It just makes it much more straightforward if you're keeping good track or spending money directly as a financial power of attorney.
Yeah. And then one other question we have is, in the years approaching somebody applying for Medicaid, what latitude exists for making, normal gifts? Somebody just making like birthday gifts, Christmas gifts, the things that we all do, right? Gift cards, smaller dollar amounts, anything like that grandma and grandpa want to give to the grandkids, right? So when you're talking about like approaching application for Medicaid does have a 5-year look back period. And what that means is the day you apply for Medicaid, you submit the application, they're going to say, show us what happened over the last 60 months, 5 years. And if any gifts occurred, you have to report them. Now, for those, quote unquote, normal gifts, kind of the standard gifts that people might make, you are able to argue that, well, look, this is a standard pattern of giving I've had. They're small gifts below a certain amount in terms of, and that's not the gift tax amount. It's like truly like a de minimis amount. We're not talking like $17,000. And it's something I've done for a long time, not in anticipation of needing care. It's just, we've made these gifts for 20 years. We give the grandkids $100 every year. You can argue that that is an exception and it wasn't a divestment because you fall under that exception of that standard pattern of giving. My concern is always that if you are concerned about needing care sometime soon, especially if those gifts are larger, like some grandparents gift $1,000 to all, or parents gift $1,000 to each kid every year to try to, show them appreciation. Those are larger gifts where you might want to be cautious, even if it is a standard pattern of giving, because you're always putting yourself then in the position of having to argue with Medicaid later on that, no, this does meet an exception. It's not a divestment. So I tend to prefer avoiding even having to report those things or make it the argument where possible. But if they have already occurred and you're stopping them going forward, but you still don't make it out a full 5 years from those gifts, then you do have some ability to argue that this was not a divestment.
And the same thing goes for charities too,
Mhm.
is a point people commonly ask. So if they have a routine of, giving to a charitable organization or, a church around a certain type of year, that those are all gifts that you have to report. It's just that you could ask for it not to be viewed as a divestment, but it's, it's up to the discretion of that caseworker. So,
yeah, so it's one of those things that the rules say we have some exceptions to these things,
yeah.
but you then have to affirmatively prove them, and that can hold up the Medicaid application at times. Sometimes it doesn't, but sometimes it does. And so if I hear someone who's come in, or someone comes in and talks to me and says, we're worried about care at some point in the future here, and it might be coming up sooner than expected, and hey, they give these gifts every year, is that okay? My advice to them might be, look, if it's possible to stop doing that, I would recommend, stopping doing that for a couple of reasons. One, we might have to tell Medicaid about it and argue with them that it wasn't a divestment. So that's something to avoid. But two, if you're worried about care costs already, grandma and grandpa might need as much of that money as possible anyway. So giving those gifts out isn't necessarily beneficial to them. Now, if they have plenty of money to gift, or they're never going to have to be on Medicaid because they just have so much money that it's not a concern, we're not talking about people like that. We're talking about somebody who care is expensive and they are worried about, hey, what's going to happen if I run out of money? So one of our other points we kind of already touched on here, but where a caregiver starts to pay for the care, the recipient of care rather, starts to pay for the caregiver's expenses, their bills, their mortgage, their utilities, whatever it is. And that would be a problem as well, because that's a gift that person is making on their behalf. You're still much better to have this written caregiver agreement that is just paying a person a wage. They can take that money and go pay those expenses. That's fine, but you're following the proper steps. If you don't have this agreement in place, or even if you do, but you're paying those expenses directly, that's still a divestment for care. So that's a pretty quick one to go through there. Another common question we get is, well, what if I'm paying a spouse for care? My spouse is providing care for me, and they, they're not a nurse or anything like that. They're just my spouse, and I want to pay them for the care they're providing. That can also be an issue, not because you're making a divestment. You can make unlimited gifts between spouses and not have it be a divestment for Medicaid. The reason, though, that this doesn't work is because you're not getting anything outside of availability. So all you're doing by paying the spouse for care is still making it available. It's still an available asset. If you said, I'm paying my spouse over a year $25,000 for the care they've provided me, as a wage. Well, okay, but that one maybe makes it taxable income again, and two, doesn't get it outside of the available assets for what that person would need to spend on their care, what Medicaid would tell them they have to spend anyway.
Yeah, so even if you have a prenup, or even if you've really treated everything as separately, Medicaid is still going to look at, the joint assets of a married couple. And there are some exceptions, and, we can talk specifically about, what a community spouse can have and all those things. But it's just important to know that Medicaid is going to look at the assets of both you and your spouse. So if you're trying to pay your spouse for their care to get that outside of Medicaid, it's never removing it from that at all, because they still look at you jointly as a married couple, even if you have traditionally treated things as separate. So.
Yeah, and we did get a question too on for Medicaid look back, what happens with 529 plans. So the contribution to a 529 plan can still be counted as a gift. I suppose you could make the same sort of arguments if it's an established pattern of giving, those sorts of things. It wouldn't be one I'd want to rely on necessarily either. And even if it's in the grandparent's name, it's established for the benefit of somebody else. So that would be still a gift at that point, and it is a countable asset for not a countable asset, but a countable divestment for Medicaid, excuse me. So it's great to establish 529 plans for somebody. I'm not saying don't do that if you can look far enough ahead, or you have the ability to, you're not funding it with I don't know that you would even do this, but hundreds of thousands of dollars, right? If you're saying, oh, we'll put like, $5,000 a year and that kind of thing, that would still be a pretty big divestment every year, but it's something that's more manageable. But again, if you're worried about care coming up in the next 5 years, or maybe even in the next 6 or 7 years, I mean, you're just concerned about it coming up sooner than expected, that's something you want to be aware of, that those could still be counted as divestments. You want to be careful.
Another thing too, and we've kind of touched on this as far as keeping good records, but I think often the thought for clients is, okay, well, I'm paying a loved one in cash, or whether that's paying them for their services, or paying them as a method of reimbursement. The idea that cash is undetected by Medicaid, and therefore that's how you can kind of get around it. You still sign when you submit a Medicaid application that you're kind of representing everything, you're proving any gifts that you've done, and that includes cash gifts. So just because you haven't paid with a debit card or other things doesn't mean that you haven't created that divestment. So then that's fraud on the Medicaid application. And actually you've made it more difficult for yourself to kind of that idea of guilty until proven innocent. You're actually creating a more difficult situation to prove that you're innocent, because if there's no real transaction logs or bank records to show that, you're actually going to have a harder time asking for an exception for some of these gifts. So it is important to have that paper trail and to document it as best as you can, whether that's, paying for care directly, but again, reimbursement, use the debit card, use a check, write why you did it, hold on to those receipts. Paying in cash doesn't get you around the issues that we've talked about.
Yeah, it's the same situation of they're going to see these cash withdrawals coming from the account. You have to report these things. They can ask for these statements, and you have to prove where they went. So even if you're paying in cash under the table, so that person doesn't have to report taxable income, or that you don't need a caregiver agreement in place, you're still going to have an issue on that side of things, both ends, because one, the person may not be reporting taxable income, and it's still a divestment then. Kind of one of the last things that can be a really big problem too is somebody trying to buy a gift for somebody. So it is a gift. They're trying to buy a gift to say, oh, thank you so much for all this care you've provided. So for all the reasons we've kind of gone through already, this is still a divestment. That's not a wage that person's receiving, and there's not a caregiver agreement in writing providing that structure for payment, right? So if somebody says, well, I'm going to buy you that Maserati, that's an outrageous example, but bear with me, for all the care you've provided to me, that's still a divestment. That's a gift that person made on behalf of, the care that was provided, but there's no agreement in place. That's not a fair wage for that. It'd be a completely unreasonable thing. So you don't want to buy large gifts saying thank you for the care. The same reason you don't want to pay under the table, because that would be a divestment. So if you need to provide care for a loved one, and that loved one wants to pay you for that care you're providing, you just need a notarized caregiver agreement in place, laying out what the wages are going to be hourly, how much is needed on an average basis, like care hours per week.
What is care?
Like what types of services are included under this? And I mean, we go through when we're drafting these, and sometimes we'll add things in for some people or remove things from what we would consider our standard language because it doesn't always apply. Like, some standard caregiver agreements might reference things like making sure that their home is, kept up and cleaned and do all of those things, but maybe that's not the service they're providing. Maybe that they have somebody coming in to do that. So it doesn't have to be a one size fits all agreement, but you also have to be careful about what you're putting in there. You can't necessarily pay a loved one to just come in and chat with you for a couple hours a week. You have to actually be doing something for you. And it does have to be a fair, reasonable wage. So we're just about out of time here, but just a quick reminder for everybody that next week we will be doing our in-person public seminar down in Oshkosh at the Culver Family Welcome Center. There's 2 sessions for that, 2 p.m. And 6 p.m. And that's our wills versus trust seminar. So we go through a lot more in-depth detail on estate planning documents, also Medicaid rules. If you'd like to sign up for that, please do so at estateplannинglive.com, or you can of course call our office as well. Just keep an eye out for an email that'll show the feedback form, where you can of course give us feedback and let us know if you'd like to reach out to set up an initial consultation, which again are complimentary. Doesn't cost you anything to come in and talk to us. And then you'll also be receiving our top 10 caregiver mistakes handout that we're mostly running through today, but some of them we skipped over just because they're similar, aren't as common, but it can be a good reference tool. And with that, I don't see any new questions. So we'll say, and we'll hope you have a good rest of your day and avoid any inclement weather that might be coming your way. But we'll look forward to seeing you guys in person.